Good morning, everyone. I'm just gonna wait for some of you guys to tune in. Come on in. Come on in. I know I said I wasn't going to be live today, but I finished my interview early. So I just wanted to jump on live real quick. I know yesterday we had a lot of questions and I wasn't able to get to the answer. So today's a good day. Let your friends know to come on in here and ask their questions. If they have questions, they should come on live. Share this live video on Facebook, Instagram, YouTube with anyone who needs it. If this is your first time, definitely say good morning, good afternoon. Let me know where you're tuning in from. Even if it's not your first time, let us know where you're tuning in from. Good morning, Ashani. Good morning, Emma. Good morning, Dehor. My name is 𝐂𝐻𝐸. For those of you who don't know me, I'm an immigration lawyer and I represent clients all over the United States with their humanitarian-based and family immigration law. Your location is not a problem. So we've got an office in Atlanta and in Orlando area, but it really doesn't matter. We represent clients in all 50 states, as I'm sure some of our clients on here can, tell you. If you want to reach us, you can call 407-995-6567, or you can schedule via WhatsApp, and that number is 404-333-8751. I'm just going to write it right now into the ticker, into Instagram to pin it. And then if you are on Facebook, you should see it scrolling through the ticker, and you can just save it that way. And if you're tuning in when this live is over on Instagram, my number is in the profile. So you need to call to schedule a consultation. All right, I think I've put it in there. Let me pin it. And you can just jump right into your question. Doha, I see you say you have a question, so just jump right into your question. Today really is a frequently asked questions. So if you have questions, ask me your questions. And do your questions, and I can jump off. Tamika Green says, "Good morning, amazing lady with purpose and love for people." Thank you so much. That's so sweet. Hey, Cleopatra. Cleopatra says, "Hello, my lawyer." Hey, Ochua baby. Good morning. Hi, Panagil says, "I'm writing from California. I'd like to get a visa for my girlfriend at the DR. Is it possible that I can get a fiance visa for her, or better to marry her there in her country?" The answer really depends on you, and whether you're ready to marry her or not. The first thing is you have to establish that you're a U.S. citizen. If you're a U.S. citizen, in order for you to file a fiance visa, you have to show that you've seen her at least once in the last 2 years. And if that's the case, and you meet the income requirements to petition for her, then you can petition for her. Otherwise, if you're ready to marry her, you can go to the DR, marry her, and then file a spousal visa, which basically converts to a green card once you come into the United States. So it's really up to you. For a lot of people, they use their family situations to determine whether or not to file a fiance visa or a green card right away for like a spouse. For instance, some people feel like, they want their spouses here, their significant other here. Let's say they're not married, as quickly as possible and choose the fiance visa route. Some people, for them, their spouses or fiance have to work. They can't be out of work because, maybe they support their family, they support children or whatever. So they just file the spousal visa so that they're still there working. And once they get approved, they'll come here and be able to work right away. So it's really up to you and her or him to determine what is your financial situation, your relationship situation, and what the best option is for you. Okay. Emmy Lashley says, "Good morning to the smart and proactive attorney." Thank you. Okay, so let me see what other questions I have here. My husband did his biometrics in July. How long does he have to wait for his work permit? For you, Miracle Powell, what kind of petition did your husband file? Because all those variables matter. Kindred says I-130 approved. I-485 pending. If I do medical, how long is it valid until I get an interview? So I need a little bit more, Kindred. I would recommend a consultation to understand your question, because I don't know if you filed your I-130 and your 485 concurrently. Did they send you an RFE to submit your medical, or did they send you a deficiency notice saying that your medical is not there? All those things I need to kind of know the answer to determine when did you do your medical, if you've done your medical. And then this other person, Loyal Love on Instagram, says my interview was exactly 1 year ago, and I received my work permit on social and my parole 4 months ago. I live in Brooklyn, and I'm just curious, when will I receive my green card? Honestly, I don't know. I don't know when USCIS is going to give it to you, because I don't know what's going on in your case or what happened in your interview. I can tell you that if you've not gotten your green card in a year after interview, it's usually a source for concern, and it means that they're doing some background investigation and making sure that your marriage is authentic. Sometimes it could be, based on a previous marriage, a previous petition, and stuff like that. So, you want to be on your P's and Q's, you and your spouse. You can also try to do congressional assistance just to see what's going on, where you ask your local congressman or congresswoman or your state senator to do an inquiry on your behalf to see what's going on, okay? Muskie says, do I need a police report to file for VAWA? So you don't need a police report, but of course, if you have one, that's helpful. But it's not a requirement. So VAWA basically asks for credible evidence. And, as long as you have enough credible evidence to show that this is actually happening to you, that should be enough. A police report is definitely not a requirement. We've had many clients that we've gotten approved without a police report. And then I also want to address a comment that somebody made that I actually just responded to before I went on live about that, where the person asked, well, what if there are people that they're not victims, maybe that they're lying on their U.S. citizen spouse, and what happens in that case? So the thing is, first of all, that's unfortunate if somebody is doing that, and that's horrible. The second thing is, at my firm, you have to have something credible, or something that we believe as true, as truly credible to take your case and submit. So because a police report is not required doesn't mean that there are not other things that we want to see to show credibility of what is happening. So, for those people, people say, oh, I need to report my spouse, that's a non-immigrant. I'm an immigration lawyer. So it's not my job to, I can't do anything for a U.S. citizen as far as reporting, but there are channels for you to report if you have a spouse that is doing something terrible to you, because it shouldn't be the case. But for us here, we don't submit frivolous claims. We want to make sure that, whoever is stating that this is what's happening to them has some sort of credible evidence. There are many people that I don't take their cases if, it doesn't seem credible, or there's just nothing that we can go with, or there's nothing that arises to the level. And then there are other times where the nature of abuse itself is that the other person, basically covers all their trail. That's really difficult to find something, and you can usually sense a lot of the sincerity. I mean, trying to be a good judge of what somebody is saying. And in those cases, we try our best to make a compelling argument for that person. And so that's why when we say, when we talk about not having a lot of evidence, that's what we mean, because sometimes that's the case. Like, if you have a spouse who's abusive, they don't want to put you on anything, they don't want to, whatever, they're like, oh, you think I don't know how immigration works and stuff like that, so that you don't have anything, they don't want to send you text messages, they don't want to do, X, Y, and Z. So sometimes that happens. Okay. Patty says, I don't have the picture of physical abuse. I want to file VAWA, but also financially and emotionally, Am I still eligible? You could still be eligible, but without a consultation, I can't tell you for a fact if you're eligible to file. But again, guys, physical abuse is not the only type of extreme cruelty or abuse that qualifies you for a VAWA case. Sometimes the abuse can be psychological, it can be emotional, it could be financially, it could be sexually, it could be an abuse of the legal system. So there are other things that, or it could even be verbal. So there are other things that we look for. Physical abuse is not the only way. And also, people misunderstand physical abuse a lot of the times. A lot of times people think that physical abuse is just you being physically punched or slapped or whatever. But sometimes, and I've talked about this ad nauseum, physical abuse could be the lack of certain things. For example, you have a pregnant spouse who you can easily put, let's say you have a pregnant spouse who's high risk. You could add her to your insurance, or you could pay for insurance, but you choose not to, and she doesn't get prenatal care because she doesn't have the money, she doesn't have the status to work, she's high risk, so she cannot work, but you're not supporting her financially to be able to go to the doctor and stuff like that. So in that case, you've not physically touched her, but that's physical abuse because it's putting her at risk of something terrible happening to her or the child. So I hope you understand, based on those examples, that sometimes it's not about just a punch and a slap. Living Above says, good morning. Do military members pay to petition for their parents? Yeah, they do. Emma says, can someone file for VAWA without any state ID? Yes, absolutely. And you can also file for VAWA even if you don't have a passport and you entered into this country without inspection. So even if you came to this country through crossing the border or through whatever, you can still file for VAWA if you qualify. So Bobby says, I have a son with mental disabilities like autism. If I show evaluation files, could we use that to expedite fiance visa from Thailand to USA? So Bobby, who are you expediting, your fiance or your son? So all of those matter. And, is his autism critical where, if it's processed later, it could cause the person to either lose their life or put their lives at risk if you're going with a medical ground. So I'm not really sure because I don't understand where your son is and what that has to do with the fiance. Okay, so Owole Joe says, I filed an I-130 for my son, but was denied because he wasn't included on my DS-260. I was given 60 days to appeal, but couldn't find a lawyer before time ran out. My question is, do I have to refile? Yeah. If you missed your window of appeal, you have to refile again. And this time, explain why you didn't include him, and hopefully that helps you. Uma says, good afternoon. I'm a citizen of Uzbekistan. Hello, this is the first time we have someone from Uzbekistan. Welcome. Someone says, Nema says, if you are in removal proceedings, can you apply for your mother that's already in the United States? No. If you're in removal proceedings, it means you don't have status. And the only way to apply for a parent is for you to be a U.S. citizen. Hi, Keisha on Facebook and Latoya. Sorry, guys, I'm looking left because I'm getting so many questions on Instagram, YouTube and Facebook. You guys are quiet today, so that's why. But feel free to drop your question in here. I'm taking questions today. Ife Luwani, what are the likely questions asked during the interview for VAWA green card? Most times, with the VAWA green card, they ask you questions based on what is on your I-485, So questions that are really critical are, i.e., dates you got married, date you lived your last 5-year address history, where you currently live when you moved there. If you've gotten divorced from your spouse when you got divorced, bringing a divorce decree. Believe it or not, you'll be amazed at how many people forget dates, and those are so critical for this with VAWA interviews. So let me go back. For your I-360, you're not going to be interviewed. They're going to either approve you or deny you at that point. In order for you to get a green card interview that's through VAWA, you must be approved for your I-360. So when you get your I-360 approved and you get to the I-485 green card interview, they can no longer ask you questions about the abuse, the bona fide nature of the marriage. They're not supposed to. Some officers will obviously go rogue and ask a few things here and there. And depending on what it is, I might advise my clients, okay, just answer that or don't answer that. Or I'll remind the officer that, this has already been adjudicated. Let us focus on this form. Sometimes we got to take our rules to them just because sometimes they forget what the rules are. But generally, that's where the focus is. And then they also focus on what your marital status is right now, if you've been divorced. And speaking of marital status, this is coming up a lot this week where people have told me they had a VAWA pending and then they got married and they didn't know that they couldn't remarry. Guys, if you remarry while your VAWA is pending, you're going to get denied, because basically it stops your process. So please, in as much as you want to move on with your life, date whoever. You don't have to sign a dotted line for marriage until you finish the process. So just wait, because if not, you've basically thrown all that hard work away. Ochua Baby says, can you divorce during the VAWA process? Also, can you remove your spouse name from anything that joins the two of you together, such as a bank account, health insurance, etc.? So technically, yes, you can file for a divorce, as long as we're able to show that that divorce is on the basis of the behavior or what's going on with you and the spouse, right? And you can file for VAWA also up until 2 years post divorce. After 2 years, you no longer qualify for VAWA, but you could possibly qualify for another relief. So it shouldn't be like an end-all be-all, because we can still screen you to see if you qualify for a T visa or for a U visa. And then going back to, can you also remove your spouse's name from anything that joins the two of you? It's up to you, and you're entitled to do that, if you want to, and if those accounts allow that. So if that's the case, for instance, I know with some banks, you and your spouse would have to sign to remove them from there. So it all really depends. Peter on Facebook says, I'm in the middle of my adjustment of status application. My wife and her brother abused me, and I'm planning to file for VAWA. Will it affect my pending I-765 EA application? Not necessarily. Depends on if you request for a continuance or an abeyance. If you do, it shouldn't affect it. Sasa says, if I got denied for a VAWA, reapply again. Is the process starting again from the beginning? Well, I'm hoping that that's not the case, but if that is the case, you should definitely consult with an attorney. Let us first of all determine why you got denied. Whether you're still in the window for an appeal, because you can do an appeal. And if you're not in the window for an appeal, whether you've passed the time to refile for VAWA, because if without those three variables, it's hard to tell you, go start again or don't start again. Esther says, hi, good morning. Please, why does VAWA process take 2 years? Girl, it beats me. I don't know why it takes 2 years. I wish it took 5 months, but with immigration or anything government related, these things take time. I really don't know. I can't tell you why it takes that long. If I knew, even if I knew, it wouldn't make a difference because it will still take that long. So unfortunately, I don't know the reason why. To file for I-485, do you need to submit your immigration medical at the same time? It depends on what you're petitioning for. In some petitions, you can. Generally, with VAWA adjustment of status, we usually say take it to the interview or wait until they request it. Now with COVID, where they've given some extensions, because before COVID, those would expire in 2 years. And if your VAWA takes a bit longer to get you scheduled for the interview, then it expires, and then you have to file a new one. And anyone that filed before 2021 has to get a new medical anyway because of the COVID requirement. So it's easier to take it then. Now, post-COVID's requirement, for marriage-based cases, you know, you could, if you wanted to, or you could take it to the interview. You know, I know like a couple of weeks ago, I told you guys, like, it's literally a unicorn to have a marriage-based case that's just approved without an interview. And fingers crossed, we're about to have our first one, which is so shocking to me because they just requested us to send medicals. But I will tell you guys when that happens, if that happens, because I don't want to get too excited if that happens, because I heard this is the route they're going. If there's no question or, you know, reasonable doubt at all, like, they should approve it just to move things forward. I was really shocked to see that. And I'm keeping my fingers crossed that this could be it for this couple. And if it is it for this couple, then when I know we have a slam dunk case, everything is there, I'm definitely going to be recommending sending medicals for marriage-based cases so that we can speed up the process. Okay, I answered this one. Ali Pumaboo says, how do you qualify for adjustment of status? There's so many ways to qualify for adjustment of status. It can be through family, it can be through employment, it can be through invested in America. It can also be through humanitarian relief that you have. So it depends, you know, like, in order to determine whether you could qualify, we would have to consult and work down through everything to see if there's anything at all that can qualify you for that. Okay. Okay, so Kappa says, what happens if you have two I-485s pending, a marriage-based initial one was denied, then refiled a new one, then refiled a new one, then the denial was now reopened after appeal. So first of all, congrats that your denial was opened after appeal. The thing is, you can never have two I-485s, so USCIS is going to close one of them and adjudicate on only one. Generally, you can have more than one petition for different things, except the I-485. The I-485, they will close one of them. Ethan says, how long does it take to get the interview after prima facie, work authorization, and travel permit? You get it after you get approved for VAWA. After you get approved for VAWA, then that will be scheduled. Sometimes it could take maybe like 3 to 6 months. But VAWA generally it takes, like for the I-360, it takes about at least, you know, 2 years. Now, having said that, we're seeing some, especially the standalones, the ones not attached to an adjustment of status, being approved a little bit earlier. But I don't know if this is going to be a standard, but because we just received a few of those, but we'll see what happens. Grateful Anderson says, good morning. Thanks for your great work. My spouse refuses to attend my rescheduled interview twice because I started filing my taxes separately after fraudulent taxes. Now she agrees she wants to attend. What is your advice? I just noticed she's seen someone behind my back. Definitely schedule a consult because you might want to consider another option. Call it 407-995-6567. Keisha says she needs an appointment. Same number, 407-995-6567. You can also send a message on WhatsApp so we can send you the link to book it yourself, 404-333-8751. Bless says, good morning. Thank you for everything you do. You're so informative as always. Thank you. I appreciate it. Kira says, what's the difference between filing VAWA alone and not with an AOS or with AOS? So first of all, AOS means adjustment of status. Filing VAWA alone means that you file just the I-130 form and you're just showing that your spouse has been extremely cruel. I'm using the spouse example, not the parent or child. And, you know, you cohabitate together, it's a good faith marriage, you're a person of good moral character. When that is approved, all you get is a work permit and deferred action. Deferred action essentially means they're deferred any kind of deportation proceeding against you, and that is renewable. So every year you just keep applying for green cards. Well, right now the VAWA approvals are coming 2-year work permits. So, sorry, not green cards, work permits. So you just renew your work permits every 2 years. That's it. If you're eligible for adjustment of status and you attach your adjustment of status to your VAWA 360 application, then it means, one, you can get your work permit and travel permit much earlier than if you filed a VAWA standalone. With the VAWA standalone, you don't get a travel permit. That's number one. And then number two, it means that when your VAWA case is approved, they will schedule you for that interview for your green card. So that's the difference. Okay, let's see what else. How long does it take to get the I-751 approved? This varies. Just like with everything else, it varies. You know, USCIS will always give you like a standard time, which is really 18 to 24 months, which is why they give the 24-month extension on your current green card. But, you know, I mean, last week we got one that was approved in 6 months. So it just really depends, you know, and it also really depends, you know, I always say to people, when you submit your application, if you're a praying person or you believe in manifesting or good energy or whatever your belief system is, you literally need to be praying that you get a good officer that has a light caseload and likes to work quickly. You know, and if you get one of those, your stuff can go by fast because it's in their control, not ours. It's just a matter of who gets your stuff. Just like with everything in life, some people work harder than others. Same applies to these officers. Good morning. Wondering if I should send proof on bona fide marriage when my husband files for adjustment of status, or should we wait for USCIS to send a request for proof? You should absolutely send proof of your marriage. If anyone is telling you that you shouldn't be sending proof that you have when you file your application, red flag, that is a problem. You should send any and everything. Basically, take the kitchen sink of evidence and throw it at USCIS when you're submitting your petition. Don't wait for them to ask you for something. You want to know why? One, you look very prepared, very organized. You make it easier for them to do your job. You make it easier for them to determine that you have a bona fide marriage. When they have to start asking you for stuff that you should have submitted in the first place, you're delaying your case. You're making it look like you don't have a bona fide marriage and you're just trying to gather things, you know, and essentially more difficult for yourself. So always, always send everything that you have that shows proof of your marriage. Now, having said that, there are going to be people who you're newlyweds, and as newlyweds, you're not going to have as much stuff as, say, someone who's been married for like a year, and you know you just got married like a couple weeks ago and you're filing. In that case, submit your application and continue as a normal married couple to acquire things organically. As you acquire things organically, you know, when it's time for the interview, all those different things that you acquired organically, take those with you to say, you know, since we've submitted our application, here are some more things that we've gotten together. What USCIS doesn't like is you get an interview notice, all of a sudden you're signing up for a bank account, signing up for health insurance, signing up for car insurance, signing up for life insurance, and everything is showing dates after you were scheduled for an interview. Same applies, you get an RFU and an NYID, and all of a sudden you're signing up for all these things because to them it means that you're only doing this because they asked to see this. So just being like, if you have a normal marriage, do what normal married people do. Like, just gather things organically as you would, you know, and just send those things. If you have them available when you file. If you don't have them available when you file, take it with you to the interview. Abby Tiwa Topper says, is not filing tax with your spouse, will not filing for tax, which your spouse make them deny your VAWA? No, that's not going to make them deny your VAWA. Is it good to file taxes with your spouse? Does it help your case? Absolutely. But does it make them deny your case? No, because again, as long as you have enough credible evidence, that one thing should not stop you. As far as evidence of a bona fide marriage, there's not one thing that's the end all be all. It's a totality combination of everything. So they're looking at, what do you guys have together in totality? So you may not have taxes, but maybe you have a house together. You may not have a house together, but maybe you guys have a lease together. You have proof that you pay your rent together, or maybe you have a bank account. So all those things are taken into consideration. Okay, let's see what else. Let me take this one on YouTube and then Facebook. Okay, I've got a question. If married to a green card holder who's yet to receive a 10-year green card, will I still be eligible for a VAWA case, or do I have to divorce her during or after the VAWA process? What do you mean they've not received your 10-year green card? So are they conditional green card holders or legal permanent residents? Because that would make a difference whether or not you qualify. Okay. Can I travel with advanced parole with no passport or travel permit? So no Megne John Gang on Facebook, a travel permit is the same thing as advanced parole. That's what it essentially means. Advanced parole is a travel permit. No, you cannot travel without a passport. You need a passport from your home country, as well as your travel permit / advanced parole, whether it comes in paper form or whether it comes as a combination card with your AAD. And before you leave the country, we want to make sure you're not in removal proceedings or deportation proceedings. Okay. Emmy Lash says, can those additional evidence during the marriage be sent to USCIS before interview after filing? No, I don't recommend sending things to USCIS if you don't have to and you have an opportunity to send it to them, to give it to them at the interview, or wait for them to get you an RFE, because a lot of times things are scanned in based on your receipt number and on your, the barcode of your RFE. So the likelihood of that stuff getting into the right hands is unlikely. So it's better to just wait and take it with you if you get those additional evidence, or wait for them to send you an RFE, and then you can place your RFE with the barcode so that they know the file to put it in. Okay. All right, guys, I'm going to take 2 more questions. When filing for VAWA, what forms do you need to fill out for your derivative child? And can I use the same form when I don't add him to my VAWA application, though separately? Okay, so good question. So those of you who have been following me for a while knows that this question is a triggering question for me, maybe because I'm a mother. There should be absolutely no reason in this life that your children should not be listed as your children on any form that you fill out. You cannot omit your children. They must be listed. It's on the same form. They must be listed. If you don't list your kids and then you're trying to list them later, like when you're now filing for naturalization, you could lose your green card and also be denied for naturalization. There is no point of not listing your kids. So if you're filing for VAWA, there is a section in there that specifically asks, name all your children. Basically, essentially, all forms that give you a path to stay here specifically ask, name your children and their date of birth and where they were born. List all your children. You don't need any extra forms, but your children must be in that form. Once you list all your children in that form and you submit it, if you get a prima facie determination letter, all your children listed there that are not U.S. citizens and are under the age of 21 will automatically get the prima facie determination letter as your derivatives. It's an automatic. There's no extra step. Okay? Now, this is the extra step I'm about to talk about. Now, if your children are here in America or your children are outside of America, the process is going to be different how to now get them the green card. For your children in America, you can attach an adjustment of status application to the VAWA application so that they can get their work permit, social security number, travel permit. And when they're approving you for the green card, they can do the same for them. Some people say, oh, my child is 2 years old, 3 years old. They don't really need an EAD. Look at it this way. You getting the EAD/travel permit for them acts as a form of identification for your children. It allows them to have a social security number. And it also allows them to travel if they need to travel. So you should always get it if they qualify for it, okay? If your children are outside of the United States, you have to wait till you're approved for your VAWA. When you're approved for your VAWA, like they were automatically included in your prima facie, they should automatically be included as the approved derivatives in your VAWA approval letter. If your children that were under 21 when you filed are not listed on there, there is an error. So that needs to be amended and you need to be reissued in your approval letter. Once you get that approval letter, then you can file, a notice. Basically, you can file for them to transfer your case to the your children's case to the National Visa Center. When it gets to the National Visa Center, that is when you will fill out like your children's visa information, and then they will send it to the consulate of wherever your children live, just like you do like consular processing, like almost like you're processing for your child or spouse outside the country. And then that is what will then bring them in here with an immigrant visa, which essentially converts to a green card. So please, guys, always include your children. One of the naturalization cases, the one yesterday, the children were not included in the initial green card application. In that case, lucky because he wasn't sure that those were his kids until later on it was discovered that those were his kids. But generally, you don't want to enter into a territory of material misrepresentation. And I know sometimes outside the country, like, if you're applying for like a visitor's visa, one of those things, they say, oh, don't include your children, or if you include your children, they're not going to approve you or something like that. It's not true. It's not true. If you're eligible for something, you'll be eligible. Same goes for those people who tell you, oh, right, you're married. Even though you're not married, just so that you can get a visitor's visa to come in here. I'm telling you guys, it is a nightmare, like proving that you're a spinster or a bachelor if you wrote on there that you were married and you really were not. And it makes it a lot more difficult and sometimes impossible to change that. So just try not to listen to that unless it's an attorney talking and somebody that handles immigration, because and they're like, oh, don't worry, I know this person, or my cousin did this, or cousin Ray did that. Forget that. Just do things the right way and make it easier for yourself. Okay. Somebody says, can you get a green card without a work permit? Yeah. If you don't apply for a work permit, you can still apply for your green card. You don't have to apply for a work permit. Or sometimes by the time the schedule, like I remember we had one client, they got married maybe like in February. We filed in March and they got their green card in June. So they didn't even have time to get the work permit. So what was that? March, April, May, June. So like 3 months. That's not the norm, but sometimes it happens. So, okay, guys, one more question and I gotta bounce. Okay. I'm going to take one on YouTube. Also, please, do you get another work permit after VAWA if you already had one, but your case got denied? If your case is denied, your VAWA case is denied, and you got a work permit through adjustment of status, your adjustment of status will be denied. So usually you should get a denial letter shortly after the 360 denial. And if your adjustment of status is denied, you'll also get your work permit denied, unfortunately. But if that's the case, definitely call. Let's see if you can appeal or if you qualify to refile. Okay, guys, I had fun chit-chatting with you guys. I know for a fact I won't be on here live tomorrow. My youngest daughter has a swim competition in school very early in the morning. So I'm going to be there cheering her on and doing some volunteer work at her school. But I will see you guys live on Friday, and I will talk to you guys later. Bye.